Don't believe so.
Sorry, not a link. Have you sent me a binder?
We have not, Your Honor.
Okay, I'm gonna probably need a binder. But let's go on the record on DC 2314469, Cheryl Banks versus Methodist Charlton Medical Center. Counsel, make your appearances.
Miles Moody here on behalf of the defendant, Methodist Hospitals of Dallas, DBA Methodist Charlton Medical Center.
Plaintiff's counsel, urge you, Mr. Jackson. Mr. Jackson, are you there?
I think the judge is saying it.
What? Isn't this Mr. Jackson's case?
Yes, it is, Your Honor.
Mr. Jackson, can you hear us? Okay, he's connecting to audio. Mr. Jackson, can you hear us okay?
Yes, Your Honor. Thank you.
Yeah, we couldn't hear you there. So go ahead and make your announcement.
I apologize. I was on mute. Governor Jackson III, on behalf of the plaintiff, Ms. Cheryl Banks, who is also present.
And did you want this on the record? We usually don't do summary judgments on the record, but we can if you want.
Yes, I would prefer it to be on the record.
All right, Tony, do you need us to start over again, or did you catch that?
I got it, Judge.
All right, let's proceed.
Your Honor, this kind of boils down to really one issue, I think, of here the plaintiff has essentially pled a fall that allegedly occurred on the July 17th. However, plaintiff herself has alleged that the fall occurred on July 14th of 2022 under different factual circumstances and scenario related to, compared to the July 17th pled fall. And part of why this is so important in this matter is that the plaintiff has in December of 2022 has made a written sworn to affidavit alleging the facts of a July 14th fall. Then in June of 2024, during her deposition, she again proceeded to testify under oath to a fall that occurred on July 14th, 2022. And then most recently in February of 2025, this year, plaintiff, in response to requests for admissions, admitted that the plaintiff's fall, which is the subject of this lawsuit, occurred on July 14th, 2022 at Defendant's Hospital. This is important because there is no evidence of a fall that occurred on July 14th, 2022 that plaintiff has presented to this court. They have no expert testimony alleging such. They have no medical records alleging such. They have no other evidence that has been attached to their response or included with their response that would allow this case to continue going forward based on those facts. Now, the admitted request for admissions is a judicial admission, and the court is required to accept that admission as plaintiff cannot even introduce conflicting testimony over any sort of objection. And so to the degree that plaintiff is seeking to contradict the July 14th admission, or the admission of the fall on July 14th, defendant would object and say that that is contradictory to the request for admission that has been answered by the plaintiff in this case. And so for that reason, there's no evidence for this case to proceed, and therefore the case should be dismissed. To the extent court believes that the request for admission is non-controlling, then the defendant would also state that that there is still a lack of causation in plaintiff's response. There is no expert testimony that has been provided or attached that is connecting the alleged fall on the 17th to any alleged harm or connecting the breach to the alleged fall. So based on that circumstance, there is simply no adequate or proficient causation testimony which is required, or causation evidence which is required. All that is in the response is one expert's testimony who has been designated for causation, one expert's testimony that actually discusses the harms, but not the causation of the alleged breach to the fall or to the damages themselves, only relating to the differences in her change after the fall was occurred. Second, there is, as to count two, or as plaintiff puts it, or which is really the second theory of medical negligence, which is that there was a alleged harm from moving the patient after her fall before having a physician monitor her. There is no allegation or evidence of causation or harm itself. In fact, one of the plaintiff's experts has even said that he doesn't think that there was any harm associated with moving her from the floor back to her bed that would not have occurred but for the fall. There's no allegations that a physician would have done anything differently. There's no allegations that a physician would have prevented anything from happening that did occur. And so therefore that cause of action that theory has no basis to continue in this lawsuit, and that should be dismissed as well. And lastly, there is absolutely no evidence of gross negligence against Methodist as a corporation in this lawsuit. In order to allege gross negligence against a corporation, the Texas Supreme Court has stated that rather than allege it against individualized employees, to allege it gross negligence against a corporation, the corporation either must have authorized or ratified the agent's grossly negligent act. The corporation was either reckless in employing the unfit agent, or the agent was a vice principal of the corporation. There is no allegations of any of such accusations in this case. There's no evidence that the corporation ratified it or authorized anything, that there's nothing that the corporation was reckless in employing the nurse in this matter. And there's no allegations that she had any ability to direct, control, or affect the hiring or firing of any employees. And therefore, there's no possible gross negligence to be able to be alleged in this lawsuit. And so for those reasons, the defendant asked the court to dismiss this case against it.
Response?
Yes, Your Honor. May it please this honorable court, taking the defendant's arguments somewhat out of order, but to make it more convenient for the court's consideration, with respect to the theory of there being a claim that there was injury caused by the movement of the patient, we will submit that we do not have any expert testimony to support that particular theory of liability. We don't have that in the deposition of any of the deposed experts that were designated in the case, so we will submit on that issue. What that does leave in play, though, are the other issues related to the breaches of the standard of care identified by Nurse Keeland, as well as the causative testimony in support of those breaches on the record by Dr. Sands. Now, taking the rest of defense counsel's arguments in turn, with respect to the grounds that the defense has put forward, that the case should be dismissed based on the persuasive, from their view, element and binding element and nature of the request for admissions, as well as the testimony of Ms. Banks confusing the date or conflicting the date of when the fall occurred between whether it occurring on July 14th or July 17th is not in and of itself a basis to dismiss on the basis under the guidance and legal standard applicable to summary judgment. First of all, that is an issue dealing with, and what we're not trying to do is dissuade this court from submitting to and recognizing the impart of the binding effect of a request for admission if in trial the defense wants to present Ms. Banks on cross-examination stating under oath that she testified and admitted in a request for admission answer in her testimony that the fall occurred on the 14th as opposed to the 17th, and she's convicted of that. All that goes to is her credibility. That does not go to the substance and nature of any other substantive claim, and the jury can take of that what it may, particularly when in the pleadings, starting with the complaint, the original amended
Mr.
petition.
Jackson, I agree with you on that. Why don't we focus more on the gross negligence?
Okay, moving in that direction, Your Honor. As to gross negligence, we simply feel, as we stated in our motion, that we have met all of the standard prima facie elements based on the testimony of and the awareness of the Nurse McDonough, that was involved in the fall. As we stated at page 18 of our motion and going through the prima facie elements, the first element, and there are two that comprise gross negligence, is that viewed from objectively from the actor's standpoint, the act or omission complained of must depart from the ordinary standard of care to such an extent that it creates an extreme degree of risk of harming others. And that's precisely what, in matching Nurse McDonough's testimony, that she knowingly took her eyes, and she's the actor in this case.
As I understand it, the argument is that for Mr. Moody is that the corporation should not be held liable for any grossly negligent conduct of their employee. Is that kind of your argument, Mr. Moody?
That's correct, Your Honor.
Well, we would disagree on that particular point of their argument just based off of the pleading of vicarious liability that we set forth in our petition and amended petition. We don't feel that the cases, as Mr. Moody has cited, to establish a demarcation between piercing the corporate veil in one instance and not in another, specifically in this case, not holding the corporation responsible. We don't agree with his assessment of the case law in that instance, and we do believe that the corporation could be and should be held liable for gross negligence based on the testimony of the nurse and the theories as pled in the complaint.
Response?
Yes, Your Honor. As to the gross negligence, there's really no controlling law that is more direct than the Texas Supreme Court. In Q West Intern Communications versus AT&T Corp., cited at 167 Southwest 3D 24 at page 26, the Texas Supreme Court said that in order to show negligence, basically, again, or gross negligence against a corporation, rather than the individual employees, to be liable for exemplary damages, a corporation is only liable if it authorizes or ratifies an agent's malice, maliciously hires an unfit agent, or acts with malice through a vice principal. None of that has been alleged in this case. There's been no evidence that has been shown that Nurse McDonough is any of that, and there's been no gross negligence directly against Methodist. And Your Honor, if I may just go back a very quick second to the argument regarding the judicial admissions of the request for admissions. Those are judicially admitted facts. That is something that must be taken into account by this court. And while, yes, some of the other arguments may be persuasive and more for trial, the fact that there is a judicial admission on the admitted facts of the basis of this lawsuit, on the date of the fall of this lawsuit, that is stated in the request for admission, the court must take that into consideration, because in Butyl versus Dallas City or Dallas County Flood Control District, the Texas Court of Appeals in Waco said that if the trier of fact were to return a finding that contradicted the judicially admitted request for admission, that the admission must be accepted as controlling, and therefore they must not accept the other finding that contradicts it. And so regardless of how this case were to proceed, this fact has to be admitted at this point. There is no ifs, ands, or buts about it. There is no way around it. That is the fact that has been judicially admitted in this court by the plaintiff themselves.
If I just may, Your Honor, briefly in closing, the one piece I will say that is evidence on the record that has been established in discovery that I do believe ratifies the acceptance of the act of Nurse McDonough is her deposition testimony, wherein she stated that she was not reprimanded, retrained, caused to have been absent from work for any period of time pending any investigation or any sort of degree of correctional behavior being assessed towards her after Methodist was fully aware, even up until, and this letter has been produced in discovery, up until the production and drafting of a letter from their risk management officer sent to Willowdean Banks, the mother of Miss Banks, regarding the complaints of the Banks family to the risk managers during Miss Cheryl Banks' hospitalization. So that fully demonstrates, I believe, ratification that would be necessary, especially when you're talking about a corporate representative being notified. We're not just talking about the healthcare providers not doing anything or the attending physician of record not reprimanding or making a recommendation in the file, but the actual risk management assessment officials, corporate officials who have been named and were quite frankly the subject of our pretrial disclosures as well as our responses to written discovery as persons with knowledge because of that very letter, we believe is the differentiating factor in this case that does demonstrate the ratification to a level that would even sustain review and muster by the appellate court. But with that, I'll submit.
Let me ask one quick question because I want to make sure I kind of understand this. So there was a request for admission, and what exactly did it ask to admit?
So, Your Honor, I can tell you exactly that. The request for admission number 4 states plaintiff's fall, which is the subject of this lawsuit, occurred on July 14th, 2022 at Defendant's Hospital. Answer, admitted. Request number 5, you fell in the hospital on July 14th, 2022. Response, admitted.
Is that not the date that the fall occurred? Were there two different, maybe I'm confused. Were there two different falls, or when did the fall actually occur?
So that is clearly what is in dispute here. The plaintiff herself adamantly believes the fall happened on July 14th, 2022, based on her affidavit, her deposition, and request for admission. The medical records suggest that the fall happened on July 17th under different circumstances, where her experts have now testified to the July 17th circumstances. Nobody has testified to July 14th circumstances.
I'm sorry, Judge, if I may, Nurse Keelan in her expert deposition was asked by Mr. Kulwicki about the conflicting date in the affidavit of Miss Banks and what is obviously the fall occurring. There is one fall, to be clear. There's no confusion on that, and it's not in dispute. What has occurred is that based on Miss Banks' best recollection, she drafted the affidavit to best memorialize the incident before we had the medical records because she knew that she fell when she was hospitalized. It came to light when we obtained the medical records, which is why we pled in our complaint the actual date of the 17th and why we have maintained that.
Let me ask this. Have you made any efforts to amend your request for admission response?
Not in that particular response, because it's been consistent with her testimony and her affidavit. And the other piece I was going to add to that is that Nurse Keelan was asked in her, and this is why, quite frankly, the amendment we didn't feel was necessary, Your Honor, because of the expert testimony on this issue. Nurse Keelan was asked what can account for Miss Banks having a difference in account of the date of when the fall occurred in her affidavit based on what you see in the medical records. And she testified because Miss Banks, based on her even training and experience treating patients who have fallen under similar or same circumstances, when they hit their head, as Miss Banks did in this case, it is not uncommon for them to have a misrecollection of when a particular event occurred, whether it was a date, a time, a morning, an
So
evening.
let me just say, let me just say this, because I say this all the time when people ask me about being a judge, and I will say that I see something new every week. So this is new. So in your petition, you say that it occurred on the 17th, but the affidavit or request for remission say that it occurred on the 14th. Am I understanding that correctly?
That's correct, Your Honor.
Then I guess I mean, people don't always remember things correctly, right? Even if they don't have a fall. I mean, I don't remember. If you told me what happened on July 14th last year, I'd have to go look at my calendar and kind of remember what happened and stuff like that. It just happens because it's, you know.
And see,
but hear me out. So it's confusing to me why you wouldn't amend now that either you can't have it both ways. Either she was wrong in her recollection, and that doesn't excuse her, you know, doesn't, then it becomes an issue just of cross-examination. But what doesn't make sense to me is that you kept the 14th when you're pleading for the request for admissions, when the 17th is what you pled. That, I mean, it's either one way or the other, you know what I mean? I don't know. It's
well, in response to Your Honor's concern, it's one way. What we did not want to try and do, quite frankly, is subvert the court or subvert counsel in trying to make it seem that we were trying to basically sham affidavit or sham answer around Miss Banks's prior affidavit, which we acknowledge has an incorrect date. Her deposition testimony, which when she's asked under oath, of course, I'm not going to and did not interrupt her to influence her to testify a certain way. And she testified based on her best memory, as she stated under oath. But what we felt was that because the expert witnesses in this case were questioned 2 and 3 hours each under the premise that the fall occurred on the 17th, and even were questioned in a non-confrontational way by Mr. Kowicki, not Mr. Moody, that you would agree, for example, that this fall occurred on the 17th as opposed to the 14th. Yes, I would agree. You would agree that Miss Banks got the affidavit, the date wrong in her affidavit, because all of the experts have seen the affidavit. They all said, yes, she got it wrong. They didn't try and come up with a reason for that. So because defense counsel continued to inquire throughout expert discovery and even during factual discovery, that there was an understanding, at least in their questioning, that the fall occurred on the 17th. That's why there was no amendment to any type of pleading away from what was the initial pleading, the petition, which stated that the fall occurred on the 17th. Miss Banks did not draft that affidavit based on any medical records. It was strictly on her recollection. So I do want to be clear, because counsel made an allegation about perjury in the pleadings and somewhat here on the record, but there's been no attempt and there is no proffer that Miss Banks has set out to perjure herself.
all right. I get it. I'm not, again, I've not seen this before. Usually when I've seen this kind of thing happen, then the party will say, oh, well, I was mistaken. It's obviously on the 17th because the records say the 17th, and that makes sense. And I've had a chance to go look at it. I don't know that this is dispositive one way or the other. It's a kind of an unusual issue. I have to admit that the clerks, I couldn't find in the clerk's record until just now your actual response. It was labeled as an objection, not a response to summary judgment, so I didn't see it. That's just, I think, the way you titled it, and I'd encourage you in the future to just call it a response if you're going to be doing this in Dallas County, at least, because it makes it harder to find in the record. Just not a big deal. What I want you to do at this point is go ahead and get me a binder with both sides briefing on it. I want to kind of take a closer look at this. If either of you want to do a 1-page brief just about this issue, if there are any cases that talk about if somebody's recollection is incorrect as to the date, I can't imagine this has come up in a Court of Appeals opinion, but if it has, or there's anything on point, feel free to do a 1-page brief on that. I don't need any briefing on anything else. Give me the binder by tomorrow morning. I want both sides briefing in it and any highlighted cases you think are important, and just get that to me by tomorrow morning, okay?
And Your Honor, if we may, just for the record, since this is on the record, counsel did avert of some of Nurse Keelan's opinions. A lot of what he suggested, well, whether or not Ms. Banks remembered or recalled or has memory issues or whatnot, those are opinions of a nurse, not a physician that is licensed to opine on such a matter of causation or a medical diagnosis. And so for that reason, we would object to those opinions on the record.
Okay. Give me that binder by tomorrow. First thing in the morning would be great. If I know it's a little bit short for time, but if you can try to put that together and get that to me, and if you can get me the 1-page brief, you don't have to get it by tomorrow, but if you get that to me as soon as possible, make sure you email it to Rhonda, ask her to print it out for me, as well as e-file it as well, if you want to, but get that to me no later than Wednesday. Just on that very narrow issue, if somebody admits to the wrong date on a request for admission, is that dispositive? Or, I've just never seen this before, so this is interesting. So we'll see if there's any case law. All right, guys, you have any questions?
That's it, Your Honor.
No